I am absolutely delighted to welcome Michael Waterstone, who will be talking on his new project on Olmsted exceptionalism. Many of you already know Michael and his work, but Michael is a professor at Loyola Los Angeles School of Law, and he's worked with a number of people here. Michael's going to speak for probably 15-20 minutes, and then we're going to open things up to questions and answers. Some of us know each other, others of us don't, so if you're asked a question, I would just ask that you introduce yourself so that Michael gets to meet you and so that other people in the room who may not know you get to meet you as well. And I also want to thank Arlene Cantor and the Disability Law and Public Policy Program, which is co-sponsoring this talk. And at the end of our session, Arlene's going to say a little bit about the lecture series this spring and some of the other opportunities that there are. Arlene, do you want to say anything else now?
No, I just want to welcome all of the non-SU College Law faculty and students. You're very welcome here. We hope you'll participate and feel free to help yourselves to lunch and enjoy. Thank you.
Great. So thank you so much, all of you, for inviting me to be here. I have been to Syracuse Law School before, although not to the new building. So it is truly wonderful to be back. I want to, first of all, thank Nina for inviting me and for doing the work to manage the logistics of the visit. I'm sure you all know this and don't need me to tell you, but Nina is an absolute star. Nina came to Loyola 2 years ago to give a talk and blew us all away. She does your school such great credit out in the world, and I'm just deeply appreciative to be her friend and colleague and have learned a lot from her. I guess I should have said at the beginning of my talk, I'm not here to run for dean. I'm happy to give a vision speech if people would like and talk about alternative revenue sources and those sorts of things, but we'll keep today more interesting. I also want to thank Arlene, whose work I've admired and been influenced by for so long, and I'm very humbled being a part of this particular speaker series. I can pretty much guarantee you, after looking at who's coming through, I will be the least interesting speaker with the kind of least impressive things to say. But Arlene, thank you for having me be a part of this. And finally, I'd be remiss if I didn't thank my friend and mentor, Peter Blank. Peter is really my earliest mentor in this field, but our relationship goes so far beyond that. Peter has become a dear friend. I'm here with my 10-year-old daughter, Ava, thank you. She's the oldest of three, and this is her reward for, being helpful, to get to come with Daddy on a trip. When Ava was born, Peter sent a little towel, the duck towel, that you used in the bath and now your younger two brothers use. So Peter and his wife Wendy sent that, and for which we are deeply appreciative. But Peter, thank you for having me. It's always great to be together. So my talk today is an outgrowth of an earlier project, and I appreciate that you granted me the favor of circulating a little bit of a hodgepodge in terms of what I sent. What I'm going to talk to you about today builds off a project that I completed recently, an article called The Costs of Easy Victory. So I actually want to spend some time on that earlier project to tee up the piece that I'm moving forward on, and I'd be so appreciative of your feedback and thoughts and really hope that we can have a robust discussion on this. So in this earlier piece, I explored two features of the disability rights movement. And even saying disability rights movement is a little bit of a loaded term. It means different things to different people. I tend to use that term in that paper as a proxy for the movement that led up to the passage of the Americans with Disabilities Act. So the features that I looked at of this social movement were, one, the low political salience, which by that I meant disability is something that is of huge concern and importance to most folks in this room, right? Otherwise you wouldn't be here. But I think we need to be honest about ourselves that disability is not something that has the political salience that race, gender, sexual orientation, gun rights, abortion, lots of other movements, people outside the movement care about them a lot more than people outside the movement care about disability. So that was one, that this is a movement with low political salience. Second, at least as constructed under the Americans with Disabilities Act, it tends to be a broad, potentially rather ambiguous category of who's actually covered within the sense of these movements. And this, the Americans with Disabilities Act definition of disability contains within it, particularly after the act was recently amended to broaden it, people who do not necessarily have any intuitive or natural claim to a history of discrimination that, again, people outside the movement would necessarily care about. So in that article, I suggest that both of these are actually really useful features to get legislation passed. To get legislation passed, you want to have as big a base as possible, and it's nice to be able to fly under the radar and not, trigger some of the culture war resistance that we see in other areas. So that's really useful to get legislation passed, but I do think that those combinations of things can shed some light on some movement disappointments. So the phrase was, there can be a downside of winning too easily. And let me say, I realize, I hope that's not perceived as trite. There are many, 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 many people who I respect and admire, many of whom are in this room, who fought and shed blood for the passage of the Americans with Disabilities Act. So when I say the cost of easy victory, I'm not saying it was easy in an objective sense. I'm just saying compared to some other social movements, it hasn't gone through some of a similar type struggle. So let me briefly explain how I got to this point, because in many cases in many ways it's an outgrowth of some earlier work. In an earlier piece to even this one, I looked at how the modern disability rights movement has proceeded almost entirely under federal statutory law. So most of you are familiar with the Americans with Disabilities Act, which was passed in 1990, and then the Americans with Disabilities Amendments Act, which was passed in 2008. So in the past, I've tried to explain why the decision to avoid constitutional law, to use constitutional law to create social change in the way that other groups have done, makes perfect sense, but also carries with it some costs. And I looked at how the seminal constitutional case discussing the rights of people, the constitutional rights of people with disabilities, a case called City of Cleburne versus Cleburne Living Center, has actually been used expansively in contexts outside the disability rights movement, particularly and most recently in the gay rights movement. But within disability law, it's pretty much always Cleburne equals people with disabilities equals rational basis equals plaintiff loses. So despite the fact that in several areas, as many in the room are aware, family law, voting, there are still state laws that expressly, and I would argue unjustly, discriminate against people with disabilities. So there was about a page in that older piece where I more or less just speculated that to the extent the disability rights movement focused primarily on getting federal legislation passed, which is something they're very good at, they might be missing an opportunity to trigger a different type of dialogue, a different type of socio-political dialogue. And I never really felt incredibly satisfied with what I did there. So in the Cost of Easy Victory, I picked that up. So my thesis there was that the limited conflict the disability rights movement went through and the broad way the category is constructed has some downside, and it may make some types of social change harder and perhaps impossible. So in that piece, first I drew on the literature which links intense social conflict to law development. And there are scholars who claim that you can really only understand doctrine in claims involving race, gender, sexual orientation, gun rights, through the conflict leading up to it. So the first thing that I would hope to convince you of is that disability is different. That the disability rights movement in the lead up to the Americans with Disabilities Act went through a fundamentally different type of conflict than in those other areas of rights claiming. And I go through that and I show that there was more multidimensional conflict in those other areas. In those other areas, there were movement goals at both the federal, state, and local level. There were specifically and clearly constructed constitutional claims. There was vigorous and multidimensional pushback, contestation, and organized counter-movements. These were salient issues. They entered the culture wars. They were things that people, even outside the core movement, cared about. Think about abortion. Think about the Civil Rights Act of 1964, when that was passed. The literature examining these areas explores feedback loops between social movements, public, and the courts. And judges become part of this discussion. So we can only understand judicial opinions through the arc of conflict, although it's rarely to either side's satisfaction. And commentators have opined that we can really only understand the evolution of certain types of social change. The Civil Rights Act of 1964, equal protection doctrine on sex, the current Supreme Court doctrine on affirmative action, as being driven by and responsive to this conflict. It's hard to envision massive change without this level of public dialogue. So I suggest that disability's got some differences, and other groups have had to fight in more places, perhaps even harder, to establish certain rights. With disability, the first thing to remember is the nature of the group, right? All groups contain differences. Anybody that says, oh, all racial categories are the same or all women are the same, that's just wrong. But disability is perhaps unique in its diffuseness. Even to say the disability rights movement is in and of itself somewhat of an overstatement. It is a modern unification of diverse groups that came together and got political power to pass a statute. These different groups could unify under the social model of disability. And I probably don't need to get into what that is for that group, but it's the idea that for this group, but it's the idea that disability, rather than being a medical issue, is a social contract. That's an social construct. It's an interaction of the individual's impairment and society's response to that impairment. The policy payoff of the buy-in to the social model was that it opened up a wide range of thinking about societal issues. But both that big tent approach and the unification under the social model push towards a broad definition of disability. And I suggest, in contrast to social change in some other areas, disability was not an issue of massive public importance when the Americans with Disabilities Act was passed. And history teaches us that the initial organizing force, a big chunk of it was actually defense on Reagan-era deregulation of the Section 504 regulations. The disability rights movement pursued a federal omnibus legislative strategy. There certainly were state disability laws before and federal laws, but the ADA went further than any other law. The movement also made an intentional effort to do this quietly. The idea was, let's not draw attention, let's fly under the radar and get the statute passed easier. There was a poll, a Harris poll, that shows that at the time the Americans with Disabilities Act was passed, only 18% of the population was even aware of the law. So contrast that to what was going on with the Civil Rights Act of 1964 when that was passed. Everybody was talking about that around their kitchen table. They were watching it on TV. It was this massively salient public issue. Now, this strategy paid off. The business community made the decision pretty quickly to not dispute the law, but rather to work for a version that they could live with. Then and now, relatively speaking, there's no organized counter-movement that battles the disability rights movement at every turn. That's not to say there are not resistance, that there are not recalcitrant defendants, that there are not, terrible people on the other side of these movement struggles, but there's no anti-disability rights foundation that shows up filing amicus briefs in every ADA case in the way that the gay rights movement goes through, or that the civil rights movement went through in the 60s. Now, this relates to the nature of the socio-political resistance to disability, which is based on a lot of things: pity, paternalism, cost concerns, but it's typically not animus. Now, and I think this continues to the present day. If we're honest with ourselves, I think we can say disability is not an issue in, let's say, judicial nominations or political campaigns in the way that those of some of us in this room might like it to be, in the way that things like race, gender, some of these other culture war issues are. So a lot of existing scholarship looks at cases going up to the Supreme Court, which have mostly been on the definition of disability, and maps the trajectory of the disability rights movement onto these standard backlash accounts. And I'm actually trying to differentiate what I'm saying and arguing that in contrast to some other areas, disability law is a story of actually more limited political resistance. Certainly there's been pushback, both publicly and in the judiciary, but it's almost all centered around the concern that this category, this amorphous category, could get too big and perhaps costly, rather than an open disagreement about the equality claims of people with more significant disabilities. That's not the public discussion or the judicial discussion that we're having. So, in the other part of this paper, I offer these differences, the lower conflict, the large category, as a new way to read Americans with Disabilities Act cases. And suggesting that this may help us understand the inability of the movement to meet some of its more transformational goals. And I want to be relatively brief here because I do want to get to the Olmstead piece. But just to fly through it, I mean, there's no shortage of scholarship on how judges got X wrong in disability cases, or why hasn't gone better in the disability rights movement. And Lord knows, I've done some of that myself with Peter and other folks. But I really do think this is a different way of thinking about things. The basic idea is there is a rather massive gap between movement expectations and what they understood the ADA to mean and what the public and or judges thought the law was, to the extent they thought about it at all, which most of them didn't. So let me offer a specific example and a general example. Specific example, employment. We all know that one of the goals of the Americans with Disabilities Act was to increase the employment of people with disabilities, and more aspirationally, to use the tool of reasonable accommodation, which was a unique feature, to restructure workplaces generally. And progressive academics, we're all in on this. The idea was that the ADA was going to lead the way to a re-envisioned workplace that would benefit lots of groups. So even noting the limitations of our measurement tools on this, and Peter may press me on this, I think we can make a judgment call with some level of certainty that this is, to say the least, has not been a massive success. Now, while it's wildly unrealistic to think that the Americans with Disabilities Act, standing alone, could, as an anti-discrimination statute, could change employment rates, it's still got to be a key part of the strategy. And the reality is that courts are not interpreting reasonable accommodation in a way to make this type of difference. Historically, over the 25 years of the ADA, they haven't gotten to reasonable accommodation much at all, mostly been on definition of disability, but even when they do, they're taking a cramped interpretation. They're not stimulating larger national discussions of things like telecommuting, flexible schedules, reassignment. My point is that this claim for transforming workplaces, that the ADA was going to be about transforming workplaces, never really went through a contested political process. But given the ambiguity in the statute, the movement needed the support of the public and judges to get the law interpreted and enforced in the way they wanted. The stage was not set for that to naturally happen. There was and is limited social and political pressure pushing judges in that direction, especially given the priors of many judges on employment discrimination law. So judges are reluctant to grant what is considered a benefit to a potentially unlimited number of people, many of whom simply just don't seem to deserve special statutory treatment. So again, there's a disconnect between what the movement thought the law was about and what the public thought the law was about. And that space wasn't being filled. Judges weren't being pushed in that direction. Similarly, more general, on this idea that the Americans with Disabilities Act was going to change the frame of how Americans thought about disability from a medical model issue to a civil rights issue, that everybody was going to get the social model. Look, it's harder to talk about the success of that than something concrete like the employment rate. And certainly, we live in a better world where disability is more recognized than a civil right, where more people intuitively get the social model than we did when the ADA was passed. So I don't want to say that there have been no successes on that area, particularly in the built environment. But, come on, we've all been to audiences, even fancy academic audiences, where people say things about disability, even well-meaning people, that make us cringe, that they would never say about other groups. And that's in elite academic circles. The cases in the Supreme Court and otherwise generally don't demonstrate judicial thinking in a social model civil rights sense. When I went out and interviewed for a previous project disability cause lawyers, the lawyers who were on the front lines bringing some of the most exciting Americans with Disabilities Act cases, one theme was that they did not believe that the judges or the public viewed disability law in civil rights terms. And even, if we're going to be honest with ourselves, academics and other civil rights movements have not always been particularly welcoming to people with disabilities as a new civil rights category. So again, although advocates believed that the Americans with Disabilities Act reflected this change, I don't think this was a widely shared sentiment. And it's not something that anyone really thought in real terms about, particularly given the backdrop of the medical-based welfare system. And even apart from the category, the universe of potential claims, expansive under this federal omnibus statute, was another complicated factor. What's the ADA about? Is it about someone with back pain trying to work around a seniority system? Or is it about someone who uses a wheelchair trying to get through the courthouse door? Both are claims under the ADA, but the public really focused on the first. So, if I'm right that this lower grade conflict left society unprepared for some of the harder and more ambitious undertakings of the Americans with Disabilities Act, and that the large definition of disability complicated things, then the Americans with Disabilities Amendments Act, the ADAAA, which was kind of a move to the same playbook. It was a doubling down on the large category of people with disabilities, may not make as much of a difference as advocates have hoped. And the law then is continued to not be perceived as transformative, but just an annoying thing that now begrudgingly applies to a larger universe of people. And I'm scared on this. And quite frankly, the reason I'm scared, one of them, is a couple years ago, I did a training for all the federal magistrate judges in the United States. Huge room. And it was on the Americans with Disabilities Amendments Act. And I was going through what the law required and, talking about it. And I could read from their faces, and I could read from the way they corralled me after the talk. They didn't get it. So you're saying this guy comes into my courtroom and his tush hurts and I need to give him extra time on whatever? I mean, they were not thinking about this law at all the way that I was. Even the left-leaning ones. And that's scary. So now let me turn to, and let me say that, this is a hard piece to write. Like, I like writing pieces that are happy and leave people in a better place and tell them what to do. And here I'm kind of just talking about some unexplored downsides of the way things have happened. I'm not attempting to operationalize this principle yet. But I think looking at Olmstead is interesting and different. And that's where I want to turn now. Because I think Olmstead can be offered in some ways, or deinstitutionalization is a counterexample. Part of this was a mind exercise in me thinking about why is Olmstead different. So for those of you that are not lawyers, Olmstead is a Supreme Court case that held that the Americans with Disabilities Act contains a requirement that individuals with severe disabilities, usually psychosocial or intellectual disabilities, are entitled to community-based treatments, to be treated in the community where appropriate. Olmstead is pretty much the only really successful Americans with Disabilities Act case that has gone to the Supreme Court. It looks and feels and acts differently than any other case that we have in our disability law canon. It's widely referred to as the Brown versus Board of Education of the disability rights movement. So in thinking about how did the court get there, particularly when other Supreme Court cases have not had particularly fruitful discussions about equality, Olmstead, I want to suggest, presents the best example of social movements working in tandem with law. So let's talk for a moment about the deinstitutionalization movement. Because with deinstitutionalization, we can actually alter the variables that I talked about above, of ambiguity in terms of who fits into the category, and conflict in ways that I want to explain. So I want to suggest that when we drill down on Olmsted, it looks richer, albeit more limited. And this is the sign that I've been talking too long, right? When the 10-year-old's bored and she's like, Dad, this sucks, I'm out. Just kidding. Thanks, Sydney. There is a more robust dialogue in Olmsted between social movements, the public, and judges. And that's one of the reasons that Olmsted's unique and a big deal in our world. So look, I'm not saying that conflict or category clarity offer the definitive causal account of why Olmsted is successful at all. I don't have the cojones to make that type of claim. But I do think we can observe some positive effects. And let me now talk about some ways that Olmsted's different from the Big Tent movement. One is that whereas the Americans with Disabilities Act in many ways is the end-all, be-all statement for disability equality, particularly with Title I, if we look at deinstitutionalization, there is a long statutory and constitutional pedigree of advocacy and litigation in this area. And we see these deeper themes from that advocacy emerge in the Olmsted opinion. We can't say that deinstitutionalization is salient in the way that abortion or affirmative action are. But you better believe that deinstitutionalization has triggered very charged political dialogues. So institutions are centers of state power. In many states, the institution is one of the largest employers in the state. The move to close these institutions triggered intense local and then even national interests. Coalitions formed. When initially the coalition was between civil libertarians and fiscal conservatives who banded with deinstitutionalization advocates versus family members who wanted to keep institutions open. So the deinstitutionalization subset of the disability rights movement was forced to go to meet the challenges that they were facing in terms of the entrenched interests. They were forced to go outside their core constituency and build coalitions with other groups. The other thing about deinstitutionalization that I think is unique is it's generally winning in the court of public opinion. It's doing pretty darn well. Very positive media coverage. And a lot of you may remember that article, that series in the New York Times last year about Iowa. I think it was called The Boys in the Bunkhouse. That was something that a lot of people paid attention to. So I read, to get specific for the lawyers in the room for a moment, I read Olmsted, in particular the Kennedy concurrence in Olmsted, to be having a real conversation about what this specific community of people with disabilities wants and needs and the problems and benefits of getting them there. And that's unique in a Supreme Court discussion, which have typically just focused on the statute is limited in this way, or kind of a very nuts and bolts statutory discussion. It was not a complete victory for disability rights advocates or the deinstitutionalization movement. Indeed, those urging that institutional placement should be okay under certain circumstances have their views reflected in the Olmsted decision. The justices did not make this up. It was a reflection of the multidimensional movement advocacy and conflicts that had gone through along the way. And I think Olmsted's one of the best tools we have moving forward. It's where some of the most exciting action is happening. As happens in equality law, it's going from one area, deinstitutionalization, and moving to sheltered workshops. So we already see it growing and expanding. I think one lesson of Olmsted to look at, or to take with us, is even within the Big Tent version of disability, you've got to win and matter in the court of public opinion. And so I think advocates are well suited to look for issue areas that have public salience. One that I have suggested and will continue to suggest is family law. There are still awful state statutes on the books. Parents with disabilities are too often having their children removed. And I think one of the lessons of the last 5-10 years watching the gay rights movement is you can find traction outside your core movement on family law issues. So I think that is something that the disability community needs to invest in. I think part of what Olmsted teaches is there may be, the Big Tent version of disability has its benefits, some political benefits, But I think to have a successful strategy, there's got to be room for disability-specific advocacy moving forward. I think our movement is mature enough that that's something to be embraced and not feared. And it's happening anyway, right? With the Section 503 regs, to get down in the weeds for those of you for a second, that kind of pit interest group against interest group. I think this discussion is particularly important at this moment, where we live in interesting times, right? In terms of people that think about bringing cases to the Supreme Court, the mantra in disability circles has been keep everything away. Those of you with little kids that go to Chuck E. Cheese, there's that game of Chuck E. Cheese where you whack things down, the little mole pops up and you whack it down. That's what the disability community has been doing. When a case comes up on cert, they whack it down. Comes up, they whack it down. For good reasons, right? That this is not a court that was, the composition looked friendly to us. But now it's a different world, right? We live in a different world than we did 3 weeks ago. So I guarantee you, because I know this, right now there are very smart people sitting around a conference room talking about what is the case that we want to bring up to the Supreme Court on a disability issue. And I think that these are the types of lessons that we want to pay attention to. Last point, I know in this overall idea, one thing I've been challenged on is that I'm advocating that introducing more intense opposition would have spelled success, right? If they just would have remembered to hit the conflict switch, it would have been fine and they would have gotten everything they wanted. And I'm not saying that. They may have lost, or gotten a very different statute, forced into other trade-offs. But I do think that the less intense conflict helps us understand the current doctrine. I'm not really trying to operationalize the proper mix of over and under the radar, but rather just making the point that it may not have been reasonable to expect certain types of progress without more people caring. So with that, I want to stop. I'm super excited for your questions and comments, and I'm happy to talk about either phase of this project or other projects. Can even answer Dean questions if people still have those. So let me open it up. And I guess, Nina, I'll call on folks. Is there a student here? Would a student like to take the first question? That's always the best. Yeah.
Me? Okay.
And what's your name?
I'm Bruce.
Hi, Bruce.
I'm 1L. And I'm wondering if you think that education and or prisons could be a hot button issue in this in your discussion.
Let me just interrupt for a second. Thank you, Bruce. And whoever wants to ask a question, if you could just press the on button on your microphone, and then when you're finished, please turn it off because we won't be able to hear more than a few at the same time.
Okay. Thank you. So I'll paraphrase Bruce's question, which was, what are my thoughts on education in prisons for being hot button topics? So thank you, Bruce. It's a terrific question. Let me preface this with, I think those are both incredibly important topics that influence lots of real people's lives. So there are terrible things going on in prisons. My wife runs a education law clinic that works at the intersection of special education and the delinquency system. And that's an area where actually the law is pretty good. And the problem is it only really works well for people with resources. So these are both, crucially important areas where there's lots of work to get done. But I'm going to answer, I think, what is your hardest question. By hot button, do you mean are these things that are going to influence public opinion in the way that we want to move that particular ball forward? I don't know that I have a better answer than anybody else in the room, but I'm not sure. And I'm going to be very candid with you. One thing that we know as advocates is no one cares about prisoners. There is a core community of people that have dedicated their lives to work with prisoners, but they tend to be the most discriminated of the most discriminated. And if I'm crafting a movement strategy, I'm not sure you want to lead with that. In terms of education, my sense of that dialogue at the moment is it has been so, corrupted, polluted, tarnished by parents with resources who are concerned that children with disabilities are taking needed resources away from their children. So while both of those are really, really important, I'm not sure those are the particular horses I want to ride at the front of this battle, just to be candid.
I guess I was talking about higher education.
Yeah, gosh, there are all kinds of important claims. And one of the things that I am committed to, along with lots of others in this room, is making sure that we are doing everything we can to bring talented law students with disabilities into our communities and investing in them to make sure that they're the ones that are going to succeed and be in the positions of power when they leave. Because that's what our bars need, that's what our country needs. In terms of the political salience of that issue, I don't know, it's a great question. I have to think more about that. I mean, it's worked for the right in affirmative action debates. I don't know. It's a good question. I don't think I have a great answer to that. Other questions? Yes.
Hi. So you talked a little bit about the move from institutions to sheltered workshops, and lately there's been some legislation on raising the minimum wage for people who work in sheltered workshops. And I've been reading, in the blogosphere, differing opinions where one group is afraid that this is going to cause some of the only employment for people with disabilities to disappear because it will become untenable. So how is that shaping the landscape of the future of programming in the communities?
Yeah, thank you for that. That's a great question. So let me kind of just explain the move, and then I'll answer the question. So Olmsted was a deinstitutionalization case that dealt with moving people from care in residential state-run institutions to in the community. Advocates have taken that model and said it is a form of unjustified segregation, exclusion for people to be working in sheltered workshops generally instead of out in the community. Part of the way that the sheltered workshop model has come up is you put a bunch of people in a room together, have them do something, and you can pay them kind of a below minimum wage to do it. When you move people into the community, you can still sustain that below minimum wage model, although it gets a little more complicated. In terms of, and that is a complicated debate, as you mentioned. There are, like institutionalization, there are people on either side saying, you can't take this away from us. This is something our community needs that works for us. And a lot of times it's parents, right? My child has been working in this sheltered workshop. This is where they get their sense of worth. And if you require a minimum wage, somehow or some way, this employment's going to go away and they're going to be left at home or even worse, in an institution. In terms of my own views on that, while being sensitive to those discussions and realizing that those are very real issues in these people's lives, the train's left the station. I mean, in the next 20 years, most people are not going to be receiving care in institutional placements, and most people are not going to be working in sheltered workshops. We as a society need to invest in better alternatives to that. And that's scary and potentially costly, although probably in the short term. But that's not the world I want my kids to be a part of. We can do better than that. Other places are doing better than that. Yeah.
So I'm Cora Trufrost. I teach international human rights law, and I'm very interested in social movements. So this piece of your article is fascinating to me. And one thing I wondered as you're moving forward with this next piece is, because I saw pieces of this in your article, is how do we measure the success of a social movement? What do we look at in terms of, sort of what is the metric that you're measuring this by, right?
Yeah.
So I believe a lot of your things, and I'm fascinated by the notion that this, I'm fascinated by it, and it resonates just anecdotally with my personal experience of the disability movement, which is not scholarly,
Yeah.
just personal, that it was a defense, like the sort of a defense against Reagan era deregulation. It makes sense to me because when I think about some of the people who would most benefit from these laws, I think of low resources, scarcity of time, scarcity of money, and so how do such vulnerable parties get the support they need to create a successful social movement? How do we know that happen? The resources, that role,
Yeah.
and it's kind of this.
Yeah, I mean, it's two questions. It's how do you measure success and how do you create success for those without resources? And look, if I had a better answer to either of those two, I'd probably be, doing something different than I'm doing now. On the second, it's so sad when you study this because money always wins in anything. So it's it does become how do you create structures that give people more opportunities. At the higher end, I have an easier time answering that at the higher end than at the lower end. At the higher end, I know that our law will only work better for people with disabilities when there are more people with disabilities in elite positions of power, right? I feel very comfortable saying that. Until we have more judges that disability is part of their life experience, more senior partners in law firms, more ALI members, and until that happens, change will continue to be slow. So we need to make investments as a community in that. In the, my wife's clinic drives me nuts, but I also love on this because Julie is able to come in. So, the IDEA, the Individuals with Disabilities Education Act, it's actually a pretty good law. And if you have resources, you can do a lot with that law. Yeah. So Julie is able, and I think you guys have a similar clinic in this regard. Julie's able to come in with her SWAT team of students, and for school districts that were treating people without resources a certain way because they didn't have resources, she's able to say, this conversation ends now. Like, we're turning this thing on a dime, and she's able to give the level of service that people with resources have to people that don't have them. But that's a Band-Aid, right? It's a wonderfully, it's a great Band-Aid to watch, but it's just a Band-Aid. So I don't have a great answer to that. On how do you measure success? I thought about that a lot while working on this paper, and I have to say, when you're talking about discrete issues, which is really what it comes down to, have employment rates moved up? Are people with disabilities more comfortable out in the world? On things like that, Peter's done that better than anyone and has been involved in those conversations. It's a melding of the social scientists, the empiricists, and it's a matter of asking the right questions to the right universe of people and gathering data. In terms of the bigger, is the social move, are people getting the social movement?
And how do you link that causally to the social
Yeah.
movement, right?
I think that's really hard. A lot of what I've done is say, well, look, we could reasonably expect that if this had more traction, this wouldn't happen. Or this universe of people wouldn't be saying X. Or, one gauge, albeit imperfect, is reading opinions. And when you have a justice in the Supreme Court saying better angels of our nature, that's pretty clear that at least that justice at that moment is not getting it. So, but those are hard questions.
Right. Well, it seems like that's the last frontier that you're talking about is the social awareness.
Yeah.
It's been missed by not having a conflict where you crack open
Yeah.
the grassroots level individual opinions. Doing it under the radar doesn't transform the social landscape, just the legal landscape.
Yeah. I think that's a helpful insight. Yeah. Yes.
I'm Janice is that on? Yeah. I'm Janice McDonald. I'm a professor of law and co-director of the Cold Case Justice Initiative. So I'm interested in your context, kind of, and comparing that with some of the other, like the racial context. One of the things that is very obvious in that area is that there are people who control what the history is of how you describe that context and the culture of how these movements arise and what the discrimination was in the past. We've run into a lot in discovering, the description of what happened in the civil rights movement and who was affected by it, that far more people, thousands of people were murdered and killed, and it's never been reported. And there's never been an examination of that, while we did have the movement that described a certain segment of it. So I was thinking about with the disability area, are you confident that those who have described what's happened in the past have accurately pictured what the kind of discrimination and the kind of efforts that people have made in the past that should be visible but are not visible to us now, and what role would that play if you were able to go after that? Would that be part of your built movement toward change and acceptability? It hasn't worked all that great in
Yeah,
race
boy,
area.
is that a wonderful question. And there are people in this room who I would love to hear answer that question for. I think it would be more interesting than my answer, but I guess I'm in the front of the room. So, I think what's out there is, and I'm generalizing, is really good is really thoughtful, in many cases is really well done, and is generally only read by like 100 people. I think what is needed is something of more general accessibility to break through,
Right.
to get people that have never cared about the disability movement to feel passion and excitement and all of those things that they feel when they think about the civil rights movement, and fear. And there have been some attempts at that, but nothing's really broke through and stuck, an eyes on the prize moment. I know that, and I'm actually.
But even that, an Eyes on the Prize gives you one picture
Sure.
of the victims and what happened, and it doesn't even touch the breadth and depth. of
You
what-
almost can't with the scope,
Right.
but there are such amazing stories.
Right.
And there are such amazing heroes of our movement that are still here but may not be in 10,
Right.
15 years. I think, so I live in LA, right? So everything's in film terms. I was at one point over several beers talking about this particular issue with a friend who's a director. And he said, you've got to talk to this other guy in our neighborhood who's the director of documentary films for HBO. So I sat down with him and just said, look, here's kind of the general stuff I do. He thought there was a there. I mean, I think there's space for something to break through to get people to care about disability. But you're absolutely right. That then becomes a high stakes moment, right? Because then that's how everybody thinks about it. I need to say, and this does not relate to your question, I love your clinic. So I spent 3 years at the University of Mississippi Law School, and I was actually in the courtroom when they retried Edgar Ray Killen for his role in the Philadelphia, Mississippi murders. I worked with the William Winter Institute on Racial Reconciliation. So I was like the only law professor that was dumb enough to go down there and be a part of it. And it was amazing and kind of opened my eyes to so many things. But I do remember, to kind of follow up on your comment, I was doing a lot of media commentary around that. Again, probably because no one else would touch it. And one of the things I remember learning and talking about is when they went to find the bodies of Schwerner, Goodman, and Cheney, they found them in this earthen dam that was
Right.
like 30 miles outside of Philadelphia, Mississippi. They found like 7 or 8 other bodies. You know, it was not, so where their justice? You know, that's not, so it's a longer conversation that we could
And-
have, but
and
that was a
with-
fascinating experience.
With disabilities, one of the things that we've found hundreds of cases that aren't on the FBI's list. There are a number of persons with certain kinds of abilities, characterized as disabilities, that were murdered, you know, and in horrendous circumstances. And there's just so much of that intersectionality of these movements, but the disability movement hasn't necessarily picked up on that as much as it could in order to tell these stories.
We had
too.
eugenics, you
Yeah.
know, here,
Oh, right, yeah.
you know, not that long ago. So absolutely. Yes, Professor Cohen.
So I'm wondering if there might be a different story you could tell from these data points, and I'm hoping you can tell me why it's wrong. But, you know, you're telling this as an issue of difference in political salience and having an enemy, between the deinstitutionalization movement and the general disability rights movement. But if you look at Olmsted and deinstitutionalization, the arguments around there are arguments largely around formal equality. And if you look at the general disability rights movement, it is very much a substantive equality approach. So I'm wondering if what you're ultimately doing here is providing a really wonderful critique of the critique of rights talk, which is saying that we can't get away, or at least we shouldn't lose sight of formal equality as we move to substantive equality, right? The disability rights movement has done a great job explaining the importance of substantive equality. But I wonder if what you're suggesting is we need to, at the same time, also be talking about formal equality. And maybe Olmsted suggests the value in doing that.
I need another sentence on your characterization of the ADA is about substantive equality as opposed to formal equality.
Because I would say this ADA is about substantive equality around reasonable accommodations, because providing the same thing to different people is recognized as inadequate, right? So it's very much a substantive equality approach. You need to provide different things to different people to meet their needs, right? So I see that as very much a substantive equality approach.
And you would think of Olmsted as formal equality because it's kind of more of a one-size-fits-all, move people from institutions into community-based
If
alternatives.
other people can receive their care in the community, I should be able to too. Give me what they are getting, which is
Yeah.
health care in the community.
Yeah. It's a really good question. I mean, I guess part of it is I'm not sure. I tend to think about the ADA as being both about formal equality and substantive equality. I think there are elements of each. And I think in terms of I think maybe what I'm trying to say is that it was sold, if anything, I think it's the same story for both the big tent movement and the deinstitutionalization. It was sold as formal equality, right? It was sold as, we just want to be treated like everybody else. We want to fit under the same model that we want to be like the civil rights movement and the women's rights movements. And sure, we may need some little different stuff, but don't worry about that. We'll talk about that later. We just want our equal rights now. And there was this reasonable accommodation provision that was put into that, but there was no public dialogue about what that was or what it meant. And I think part of what I'm trying to say is those harder substantive law conversations, that was going to be punted and played out in the case law, but there was no dedicated social movement guiding those conversations in a politically salient way. I guess the same could be said about Olmsted in the sense that we want our formal equality, and the devil lies in the details in terms of how you actually do this. So in a way, I guess for me, that it seems like almost, and this is probably could be said about all law, right? You start out with big formal digestible claims and then work out the more complicated stuff later. So I'm not sure that totally answers your question. I feel like I'm muddling through it. Yeah, I'll go there.
I'm Lauren Goulden. I'm on the College of Law faculty also. I think my question follows on Nina's, because what I've been sitting here trying to think about is the distinction that you're drawing between the different movements. And I was thinking about it as more of when you actually get to where you have to expend resources to make the equality happen. All of the movements, well, not all of them, because some of them don't necessarily entail costs, but certainly the civil rights movement, if you actually look at the picture where it's broken down, is because we aren't willing to reallocate resources in the way that would ensure actual, I think, the kind of substantive equality. So I think there's really something to what Nina's saying. I mean, and so there isn't animus. I liked your argument about that. There isn't animus to the formal equality claims of the disability
Right.
movement in the way that there has been to LGBT or to other sorts of racial movements. But I think if you look particularly, I guess partly I wanted to push because I liked Bruce's question earlier, because what I think about is when you do, and you raised this, when you do actually get into the school setting and you need the reallocation of resources to make that equality happen, that's where and you say it, you confront,
Yeah.
it's not animus, but it's resistance in that moment. It's, I guess, below the radar of the community.
That's really
I don't know
helpful.
where I'm going, but.
So no, I think what you're saying, if I can kind of now make sense of both of your questions, and I'm not sure I have a great response to this, is you're saying, look, in any social movement, it's kind of a two-step thing. Step one, get people to recognize or buy into our formal claims of equality. Then once you get through that door, step two is figuring out ways to convince society to spend resources to really change things, right? And other groups, under my theory, have had to fight harder to get through the door, and we're all kind of stymied on the resource issue. The disability community, I'm suggesting, got through that first door a little bit easier, but is now stuck at the same place that everybody else is stuck. I guess what I need to think about and figure out if I'm doing a good job on is whether that fight to get you through the first door, I think my instinct and what I tried to spell out is that fight to get you through the first door of formal equality gives you some built-in headwinds to make progress on the second, because at that point you've already built allies, you've already gotten people outside your core group to care, you've already got politicians who are invested in a meaningful level in the success of your enterprise. So my instinct is that you are better positioned to do well on those resource allocation decisions, and that because the disability community got through that first hurdle a little easier, they're kind of maybe less prepared to fight those resource allocation decisions. But this is a helpful way to think about it, and I don't think I do a particularly good job of laying it out like that.
Can I just follow, the one
Yeah,
question, the only thing you didn't mention just now in talking about how you get through the second door, which I thought was part of your piece, was that you've gotten through the first door now with constitutional-based tools instead of just statutory-based tools. So
Well, that's part of it. I mean, under the statutory-based tools that we have, it's always reasonable, and there are very few absolutes, where constitutional law tends to have less of an undue burden defense or something like that. So that, I think, is a difference as well. Yeah.
I think we're very much on the same wavelength, because when I read the piece, what struck me as kind of a question that you could ask is whether the Olmsted is so different than the ADA cases, because Olmsted, like the busing segregation, the restaurant segregation, the racial discrimination cases from the past, including Brown, were basically saying, treat us the same. It was an issue that is so inbred in American culture of rugged individualism. We just want people to be able to be treated the same, and then they're going to pick themselves up by their own bootstraps. And that's very much, I think, underlying the Olmsted majority and concurrence opinions, as opposed to, and I'll get to in a minute, the dissent, which I want to ask you about. And so this idea that the disability rights group, yeah, they should have the rights and freedoms, I think is exactly what's underlying a difference of Olmsted and the other cases. So that may be, if you, I don't know if that's worth spelling out more clearly. Second point about Olmsted and the deinstitutionalization, and I have to say I really feel old right now because I feel like you're talking about my history. I mean, the Mental Health Law Project, where I started out, was the organization that brought all the early cases you cited, Youngberg, O'Connor versus Donaldson. But the piece that is absent, which is so interesting in light of Bruce's question, is that Bruce Ennis was one of the founders of the Mental Health Law Project, and his training was around prisoner rights litigation. And I remember meeting Bruce many times in my early years as a lawyer, who explained that it was taking those theories of institutionalization of prison and just applying them to those people we went to visit at St. Elizabeth's Hospital, Mental Hospital. Arlene, it's the same. Remember, you visited prisons when you were in law school. And that connection around prisoner may be interesting to explore. So maybe to follow up on Bruce. And the last question is the dissent, okay? So the dissent makes a big deal of saying, you know, what is this business? The majority is talking about discrimination between people with disabilities and people without disabilities. Because the dissent is saying there's no such thing as discrimination among people with disabilities. And I wondered if you had any insight into that dissent's view, how to continue to counter it, that discrimination can't be among people with disabilities, because as we know, it is.
Yeah. So let me take the first comment, and then I'll come to the second. That's really helpful, and I think absolutely right. I would note that one key difference right off the front with deinstitutionalization and the ADA project writ large were brought and conceived by cause lawyers like yourself. When you look, I did an earlier project, when you look at every ADA case that went up to the Supreme Court, only one of them, Bragdon versus Abbott, was quarterbacked from the ground up by a cause lawyer. And that was actually a gay rights group. It was Lambda Legal in Massachusetts. So it is the cases that have gone up to the Supreme Court were not the type of cases that deinstitutionalization advocates were bringing at the beginning, where you kind of create a case to make the point of law that you're doing. I think the disability community is keyed into that moving forward. I think this is going to be a maturation point for the movement, where they realize if we want to make points of law, either statutory or under constitutional law, you got to pick the right plaintiff. I mean, you got to do all kinds of things from the ground up. You got to pick the right circuit. You know, there's an art to doing this that is not the local lawyer who could be a wonderful person kind of taking a case up. And that game has gotten more complicated with the proliferation of these Supreme Court clinics, right? And the professionalized bar that will now troll looking for circuit splits, looking to try to take any case up just because it's a chance to get it up. Okay, so now to the dissent. God, that view is always there, and I don't know how you make it go away, because, and part of it is it's in, I feel like, I don't know if that's unique to disability, right? There are overlays of that in employment discrimination law with race, with gender, this kind of, all women are the same, all African Americans are the same. I mean, it seems particularly idiotic. I mean, it's idiotic across the board. People are different, but I don't know how you make that view go away. I have no thoughts on that.
I just would say, one for follow-up, is that I think it supports, I think probing a little bit into the dissent and coming up with this response supports your argument
Yeah.
that the disability group writ large does present different issues. I think there are different
Yeah.
issues about distinguishing among impairments within the group of people with disabilities. And I think ultimately it responds to your initial point about where's the excitement in the public view. It's not necessarily excitement, it's fear. I mean, one thing we haven't said is disability is among us
Yeah.
in a way that I will never become an African American. And I very well may become a person with a disability. Maybe I have been. So that issue, I think, supports your argument. I think teasing it out a little bit, I don't know how, I mean, we should keep in touch.
Yeah, yeah.
But I think that to tease it out a little bit could help highlight where that public view
Yeah,
could
no,
go in the future, not just where it hasn't been in the
I
past.
think that's the kind of million-dollar question. Right? It should be something that more people relate to. It's the one minority group. We could all join at any time, right? We're all temporarily able. Yeah.
Hi, thank you. I'm Mary Helen McNeil from the Kingston College of Law. I'm sitting here thinking about the, excuse me, the marriage equality movement and where that fits into your theory. Not that it has been an easy success, but fast. And, you know, I was not and have not been in the trenches on it at all. I don't mean that, but at least from a distance, it seems like it was very fast.
Yeah.
And does that mean it's an easy victory? I don't know. And how would that fit with what happens next?
Yeah, no, thank you. And I've talked a lot about that at various points. My friend and colleague, Doug Nejame, who Nina knows, we had hours of discussions on this, and he has been in the trenches on that one. And we would have these moments where let me put it this way. At the very same, when the Americans with Disabilities Amendments Act was being negotiated, one thing that was happening was the language in the original Americans with Disabilities Act that says people with disabilities are a discrete and insular minority that kind of was intentionally directed to go towards Cleburne, towards a move for heightened equal protection status. At the same point that was happening, Bill Eskridge was giving testimony in Congress as to why LGBT category is entitled to heightened protection under the Equal Protection Clause. So you have a rare moment in time where kind of two movements are betting on different trains, right? One on the statutory model, one on the constitutional model. It would blow Doug's mind that when an ADA case would go up to the Supreme Court, there weren't 30 groups that were committed to the eradication of the Disability Rights Project, showing up, filing amicus briefs, doing media accounts, and it would blow my mind that they couldn't just go get ENDA passed, right? Because it's kind of like we can get whatever statute we want passed. We're actually really good at that, but we can't buy a victory in the Supreme Court. You are actually doing a pretty decent court strategy, but the legislators aren't your friends. You don't want to attribute too much kind of causal success to those different models, but I will tell you that I think one lesson that I take from the gay rights movement is, yes, a lot's changed really quickly, like super quickly in social movement terms, but they lost in the Supreme Court with Bowers. That was a big, devastating moment. At that point, there were, and this is another difference between the movements, literally post-Bowers, there were like 7 smart lawyers that sat around a room and quarterbacked a strategy. And the strategy was, we're going to go to state courts, we're going to do family law cases, we're going to kind of get those ducks in a row, we're going to change state laws bit by bit, and then ultimately come back to the Supreme Court when we think we've got a stronger hand. And they were ruthless, like the NAACP was in the 60s, by the way, about shooting down anyone that tried to deviate from that strategy. And the movement was kind of insular enough that they were able to do that. Contrast that with the disability rights movement. I was struck when I started interviewing disability cause lawyers. I kind of knew a lot of them from some, but a lot of times people didn't know each other. I mean, these are the key people in the movement. It's a movement that often, because even calling it a movement's a little overstated, right? You have different groups built up around individuals with different life experiences. Very diffuse, very little central mobilization, no kind of here's our 5, 10, 20-year plan. Now, some of that's changing, but the movements are just so different. So I think that's a big piece of it.
Michael, I think we have time for one more question.
Okay. Yes, in the back.
Hi, is this working? Thank you very much for your comments. And I was thinking about coalitional and multi-issue politics as compared to single-issue politics the whole time you were talking. And I think sometimes there's a conflation between the word gay and the LGBT multi-community approach. And I think that although I'm not going to go off on a tangent about marriage equality, it certainly hasn't improved the quality of life of most trans people of color who are prisoners. Or numerous other people who are marginalized by virtue of the assimilation that accompanies the right to marry, which I'm not saying I'm against. I'm saying it's not really good enough, so, but it's better than what it was, and how soon it happened is another matter. I think it's taken quite long, actually, for that to occur. But I'm not a lawyer, although I don't play one on TV either, and I think a lot about the role of law and advocacy and social justice, and law not just being a framework, but the potential to be a cultural context changer. I don't know if this is my political background or my family of origin. But I think one of the reasons Olmstead is distinct from a lot of the other legal structures that you've been talking about is because it is foundationally efficacious because of the nothing about us without us approach, and that it was people who were part of the movement, the so-called movement, which is not monolithic either, right, but who helped that happen. And the Kennedy example is salient there. And I guess I also wanted to just quickly say that I think the idea of measuring change in certain ways, that if you imagine, and this is following Cora's excellent point, like the no, I'll say the no is still an engine of change. The antithesis in Marxist dialectics is still important. Like the no still matters, like a refusal to accept, and so dissent can be productive, but doesn't have to be. So I guess I wanted to ask you, you said something about salience, and deinstitutionalization is not salient in the way that abortion is. And so I'll say something potentially controversial. I think institutionalization is a form of social erasure in a way that is arguably different, but not that different from eugenics, and is a kind of eugenics in the social sense. So when people are institutionalized, they're experiencing social control, which is differently nefarious than what happens with abortion for certain political reasons. And so I'm pro-choice and pro-disability rights. I have to deal with that tension all the time.
Yeah.
And so when there are abortion of children with disabilities, and it's controversial and necessarily an ethical subject of discussion, but I don't think that deinstitutionalization is less salient than that. I think it's differently salient than that. So I just wanted to ask you if you
Yeah.
could comment on any of that. I know that was a lot of stuff, but
Yeah, no, thank you for that. And I agree with you. I guess my point on political salience was I could walk to Starbucks, right? And I could ask the nice person behind the counter, what are your views on abortion? And they would have views. I could ask the nice person, what are your views on deinstitutionalization? And they might have views, they might not have views. If I explained it to them, they might have views. But they're a lot more likely to base their political, consumer, other types of behaviors off feelings that they have about abortion than deinstitutionalization, despite the fact that both of those, I think I could make a case, as you're doing, that both those are real in potentially your life. One has just jumped the tank or jumped the fish pond or whatever the metaphor is into an issue of national political dialogue more than the other has. And I actually think deinstitutionalization has more traction out in the world than a lot of the other things the ADA talks about. So I guess we're out of time. I'm happy to hang out. Thank you all so much. This has been a terrific group and a terrific audience, and I'm really appreciative of the opportunity to be here. Thank you.
Thank you so much, Michael. That was just fabulous. And I want to turn things over to Arlene to tell you a little bit about some of the other speakers planned, because it's a really amazing series. Arlene?
yeah, I just want to say thank you. It was just such a joy, and I hope that we'll continue conversations, have you back here again. And I just want to thank all of you for coming. Really, it was a wonderful, I thought, enlightened discussion, which we have to have more of here. So thank you, Nina, for organizing it as well. I want to just mention a couple things. On March 22nd, we're having Stephanie Ortaleva, who is the founder of Women Enabled International, who does amazing work around the world on behalf of and with women with disabilities. Particularly, she's going to talk a little bit about a project to raise awareness about violence against women with disabilities and other things. On April 5th, we're having Sam Baganos, who is another ADA scholar, and he will be here talking about kind of more on the ADA and where we're going from here. That's April 5th. And April 12th, we're having Sagit Moore, who's a professor at Haifa University in Israel and Washington University this year as a visitor, who's going to look at issues of bioethics and disability. And the interesting news that you're hearing first is that Sue Swenson, who had to cancel, Sue Swenson is the Deputy Assistant Secretary at the U.S. Department of Education, Department of Special Education. She had to cancel. She was actually quite ill with a flu that turned into pneumonia. She's going to come, and she's going to come here on April 18th, 19th. So that, I just found out this week. We've just confirmed plans, and I'll send around emails and let people know. So thank you so very much for coming, and thank you, Michael and Nina, for convening this, really.